Good morning, everyone. Thank you for joining us. This is an important session. I know we've all been working very hard on it, and many of us have attended several sessions on the imminent changes. To start the program this morning, I'd like to ask Enos and Gachana to open the proceedings for us, and then we will move from there. Enos, I'm going to hand over to you now. Thank you.
Thank you, Wayne. Good morning, everybody. Morning to our participants. Let me also take this opportunity to greet our wonderful speakers that we have. As you can see, we've got a lineup of experts in this area that we're going to be addressing this morning. As you know, our topic for today is on changes to the retirement funds benefit that are going to be effective as from the 1st of March 2021. As already stated, I'm going to introduce our wonderful speakers who are going to provide an interesting discussion this morning. Without further ado, let me start by introducing our current president, Geraldine Fowler, who's also going to provide a brief overview on the areas that we're going to be discussing this morning. Welcome, Geraldine. Let me move on to introduce our speakers. Now that I've introduced Geraldine, we've got Hendy Jube, who's also going to be taking us through some of the exciting developments around the benefits that are effective as of March 2021. The other speaker is Nancy Andrews, who's also a chairperson of our Legal and Tax Committee. We also have Jenny Gordon, who's also a member of our Legal and Tax Committee. On the podium as well, we have Wayne Haler van Rensburg, who's our current executive officer at the Office of the Institute of the Retirement Funds, Africa. Thank you very much. Thanks, Wayne. Welcome to our speakers. Thank you.
Thank you, Enos. I'm going to hand over to Geraldine now. Thank you.
Yes, let's hand over to Geraldine. Thank you.
Thank you.
Thank you very much, Enos and Wayne. Good morning, everyone, and welcome to our session. As Enos said, I'm just very briefly, the excitement of the morning lies with our esteemed speakers, who I'm very much looking forward to listening to. We've all, as Enos and Wayne said, we've all listened to many of these sessions on the when it was still the Taxation Law Amendment Bill, and then now it's become the Taxation Law Amendment Act. But I don't think at this point we can hear enough about it, because every time we hear something about it, it just gets reinforced with what needs to be done. So the talks for today is really part of the greater reform on retirement funds. And we know that for some years now, in fact, going back to 2013, there was some legislative changes with regards to retirement reform that has been introduced. And since then, we have seen a steady path. And I think the underlying focus of it all is that the reform is being implemented to ensure better outcomes for everyone that retires. So the changes that we've seen that has taken place in the last few years, we will recall in 2016, the tax treatment of contributions changed. There was no more differentiation between the tax relief that could be enjoyed on contributions, and the incentive was up to 27.5%. We then saw the introduction of the default regulations come in 2019, and we now find ourselves with the changes that's going to come in 1 March 2021. And that is the steady path that has been taken, and I have got no doubt we will, in the years ahead, see even more changes come about. But just very briefly, what's going to be covered today is that, as we know, there's still some areas of uncertainty. Transfer between funds, effective 1 March, the treatment of February contributions and rear contributions, and then also some issues or uncertainties with regards to partial withdrawals and benefits from preservation funds. And then the second section we will look at is a practical view and implementation of these changes that has come about, or that is coming about 1 March. What does retirement fund administrators need to do? What must the consultants do? What must the employer do? And what type of communication should we be looking at? And then lastly, very important, is there's been a lot of talk in the media and in the industry about this, the changes that the 3-year immigration changes that has been introduced, which I'm sure we're looking forward to hearing from. But that's enough said from me. Once again, thank you very much for everyone that is attending, for our legal and technical committee that has put this together, our past president, Enos, to always give us a warm welcome. And then, as always, the effort from our executive officer, Wayne, in putting it all together. Thanks very much, everyone. And we will now listen to our speakers.
Thank you, Geraldine. Hetty, it's over to you now. Let us know if you need any support there, but I know you're a very capable human being. If you want to switch on your camera and your microphone and help us understand some of these uncertainties that you've highlighted.
Hello, everyone. It's nice to see so many of you attending. I hope that we can clarify some of the uncertainties this morning. I see there was one question coming in regarding the rear contributions. I hope that I've got good news for you. I'm only going to cover 4 topics. I'm going to be very, very brief on it. The first one is the transfer between funds before and after the 1st of March. Now, the question is, what is the situation if your Section 14's effective date was before the 1st of March, but the assets are only transferred or the approval is only received after the 1st of March? There are 2 different stances in the industry. The first one says, look at when your membership terminates, and that will depend on the rules of the transferring fund. The second one says, no, that's not what you must do. You must look at the effective date and then the legislation as it applied on that effective date. Now, the first, if you follow the first one, it means that if your Section 14 is only approved after the 1st of March and or the transfer of the members is only done after the 1st of March, then you would have been a member of the Provident Fund on the 1st of March, the one that you're transferring from, and then the vested benefit should apply. The second stance, if you look at the effective date, irrespective of when the transfer is then approved or the assets and members transferred, the effective date is the determining factor. So if the effective date was before the 1st of March, it actually then means that your membership effectively terminated on that date, and you will no longer be a member of the Provident Fund on the 1st of March. Now, I'm not saying which one is right. We're hoping to get some clarity from the regulators, so keep your fingers crossed for that one. Then the second one, the February contributions.
Hetty, sorry, can I interrupt you for a second? I just want to ask one thing. I don't know if you can maybe move a bit closer to your microphone. So just a little bit.
Okay, let me just put the volume on a bit and maybe that will help. Is this better?
Thank you. Thank you, Hetty.
Okay,
thank you.
Sorry for that.
No problem. Thanks so much.
The second one relating to contributions. We received a letter from SARS yesterday. It's a non-binding private opinion in which they say that you have to look at when the deduction for the contributions apply. That means that even though your February contributions might only be paid in March, because the members already got a deduction for those contributions, that is in your vested funds. Now, although they didn't say that very specifically, The same should also apply for any arrear contributions that were due and payable before the 1st of March, but are then only paid after the 1st of March. So I hope that addresses your question, Gordon. The last one, the third one, the lump sum disability benefits.
Hetty, sorry. Can I just ask you to just pause on that one, because it's quite big news, yes, and maybe just take us through it one more time. Yes, thank you, please. Yeah.
Should I wait for the applause?
Thank you.
Let me just reiterate. Your February contributions, even though it is only paid after the 1st of March, because the members got the deduction for those contributions in February, it will qualify as vested benefits. So it will be added to your vested benefit part. And as I said, although it didn't very, very specifically say so, the same should apply for all arrear contributions that were due and payable before the 1st of March, on which the members already got the tax deduction. If it's paid after the 1st of March, it should form part of your vested benefits. Good. Then that same letter that SARS sent yesterday, they also confirmed that what the portion of your contribution that should be taken into account for determining your vested benefit is not inclusive of your admin costs and your risk benefits. Now, there are also on the lump sum disability benefits 2 different schools of thought. The one say, look at when the disability benefit accrues to you. If it only accrues to you and you only become entitled to it after the 1st of March, then it cannot be part of your vested benefit. Now, remember, we're only talking about the risk component of your lump sum benefit. We're not talking about the retirement savings part of it. Now, my personal opinion is that if your contribution, only the portion that goes towards retirement savings, not the risk benefit component of the premium, if that's not part of your vested benefit, then in my opinion, you cannot say that a lump sum disability benefit, the premium that was payable up to the 1st of March should form part of your vested benefit. In my opinion, this is only when the benefit becomes due and payable to you. For some people, obviously, that will never happen because you have to be disabled to qualify for that benefit. So if you never qualify for that benefit, it's never going to form part of vested or unvested. If you already become entitled to it before the 1st of March, then it will form part of your vested benefit part. Now, when do you become entitled to it? That will depend on the policy wording. Most policies will say it is only when the insurer accepts your claim. So it's not when you put in your application for lump sum disability, it's when the insurer says, yes, you are disabled, you can now qualify for the benefit. And then on the last one.
Hetty, maybe, can I interrupt you again and ask you, can you maybe think of an example, or am I asking too much on this lump sum disability option?
So let's say in your fund, the rules state that when you become disabled, you will qualify for both whatever is in your retirement savings pot and a multiple of salary that is insured with an insurer. Now you become disabled on, let's say, on the 1st of February this year. You put in your application, it goes to the insurer. The policy says that the insurer has 60 days within which to consider whether you qualify for the benefit or not. If the insurer then comes back to you in April and says to you, okay, fine, I believe that you do qualify for this benefit, then only then do you become entitled to the benefit. So the fund will then pay you the retirement savings portion of your benefit, and that will be split into the vested, non-vested parts. Everything before the 1st of March vested, everything after 1st of March non-vested. But the multiple of salary portion, that will only be paid to you after the 1st of March, so that whole portion will form part of your non-vested benefits. That you Wayne?
Sorry, I couldn't unmute myself fast enough. So I just wanted to understand. So if I'm a Provident Fund member, just to understand, I become disabled, my savings portion, I'm going to call it that in a simplified form, that's not going to be vested, but the insured portion will now form part of the vested benefit? And if I wanted to take the benefit, how's that going to be paid?
Okay, remember, your fund benefit, the retirement savings component of your benefit, that will be split into vested, meaning everything that accrued up to the 1st of March, and non-vested, the benefit that's built up after the 1st of March. Because remember, if you apply for disability benefits, it doesn't mean that your contributions stop. So you will continue making contributions, and all the contributions that you've been made from the 1st of March up to April, when your disability claim is approved, that will form part of your non-vested benefit pot. When your multiple of salary is then paid out to you, that should go to your non-vested pot, because it's only payable after the 1st of March.
I think that helps us, but if there are more questions and things, I think we are going to try, we're going to put together something after the session, and we'll put it in writing as well, and hopefully it will be meaningful to participants and other people who need to understand that. Thank you, Hetty.
Perfect. Okay, so the last issue relates to a member in a pension or a provident fund who resigns and then takes a portion of their benefit as a lump sum and transfer the rest to another fund, or somebody in a pension or provident preservation fund that take one pre-retirement withdrawal. Now the question is, how should that be split into vested, non-vested? Should we do it exactly the same as we do for all the other Section 37D deductions? But just to put you in the picture on that one, the Act is very clear. It says that for any Section 37D deduction, so that's divorce, maintenance, amounts owing to employers, housing loans, you have to split it proportionately between vested and non-vested when you take the benefit. Now, unfortunately, the legislation doesn't say anything about a member that takes a portion of their benefit as a lump sum when they resign, or somebody in a preservation fund that takes a pre-retirement withdrawal. So we asked SARS to please give us clarity on that. We all thought that the same principle should apply. It's just logic. I mean, if the proportionality applies for the one set of benefits, why not also for the other? Then yesterday, SARS came back to us and said, no, the legislation does not say that it applies proportionately. So every administrator has to decide how they want to apply this. Now, this is a bit of a curveball. We really expected them to say follow the same principle as the other one, but they didn't. So this leaves all the administrators in a conundrum now. Do you follow the same principle as that applied for Section 37D deductions, or do you take a pre-retirement withdrawal from everything from vested or everything from non-vested? I think you'll all agree with me that the option that will suit the member the best is if you take the pre-retirement withdrawal from the non-vested benefit. I'm not saying you have to do that. I'm not saying do it proportionate. I'm not saying taking everything from vested. Everybody will have to decide for themselves. Good luck with that one. Anything else that's unclear?
Nothing. There's one question, and maybe we have a minute or two. It was just from someone saying, does it make a difference for the lump sum disability whether the person is younger or older than 55?
Yeah, it will. Let me just think about it. For a 55-year-old, somebody that's 55 and older on the 1st of March, everything in that fund, doesn't matter how it's built up, everything will be paid, or will be part of your vested benefit if you stay in that same fund. So yes, it should make a difference for younger or older than 55, because it doesn't make sense for an older than 55 to split the two. As I said, everything built up to the 1st of March, and everything built up from the 1st of March until the date of exit from the fund will form part of your vested fund.
Thank you, Hetty. Is there anything else you want to share at the moment? We can always write some stuff afterwards if there's anything else that comes to mind, and based on the questions we received as well.
Yeah, I see that there's one question. Where can we get that non-binding opinion from SARS? I don't know if that's something that you guys are going to make available, Wayne, the letter that we got from SARS yesterday.
I think we'll share it with our members. I don't think we'll be able to share it with because the letter is addressed to our members. So we will be able to share it with people who are members of the IRF. Thank you.
That's all from me then.
Thank you.
Everyone.
Nancy, can we ask you to take us through your portion, please?
Yes, thanks, Wayne. Good morning, everyone. Obviously, a lot has been said about annuitisation, and part of this actually has an impact practically for administrators, for the fund itself, and for employers that participate in umbrella funds or in who have established a standalone fund. So I'm going to actually deal with that part of it and kind of give an insight into what funds need to be concerned about, what the administrator needs to do. And this is purely my view. It is different administrators, different funds who have consultants may have a different view on it, but it's something that I've actually said would apply overall. So please do not actually assume that if I'm saying something here and your fund hasn't done it, it's incorrect, or whatever or whatever the reason may be for you not doing it, and it's late, and you have issues on it. So from a fund perspective, I mean, there's important parts of the fund, the fund rules that need to be changed, how trustees look at communicating to members going forward, and retirement benefit counselling or retirement benefit counsellors, and also your fund consultants. So, so let me deal with the first issue on communication to members. By now, as retirement funds, we should have communicated to Provident Fund members to kind of say, this legislation is coming into effect in 1 March. This is the possible implications for you. And based on that, we will keep you updated, or we will send you further communication. You could have done that either through a letter from the fund, or most funds actually issue their trustee report. So you could have introduced it into your trustee report and made members aware of it. Importantly, the communication to members on a Section 14 transfer. So members on a Section 14, so generally, well, it's a requirement that trustees have to sign off on your Section 14 transfers. Part of the Section 14 transfer process is the requirement for you to, for part of the retirement fund process is, the Section 14 process is your communication to members. It's important that for trustees, when signing off the Section 14 application, that they check the communication to members to make sure that this issue on annuitisation has been clearly explained in the communication to members. Importantly, they have to clearly distinguish, you have to see the clear distinction between the younger than 55s and the 55s and older, and how benefits would be payable on retirement. And specifically that if you for members over 55, if they remained in the fund, what they would be entitled to, and if they transferred to a new fund, what they would also be entitled to. So that part of the communication exercise that that generally consultants to the fund or administrators do on behalf of the fund has to actually make, has to be clear enough that when trustees are actually signing off these Section 14 applications, the communication has been made to members. So that is one of the big issues that we will see going forward. I mean, this is our standard communication now kind of says, well, you're moving from Fund A to Fund B. The reason because your employers decided to actually do this because of whatever reasons, your benefits would not be affected. You are not being prejudiced. In fact, you would receive better benefits. But the issue that needs to be covered very specifically in this communication is how this is going to impact Provident Fund members going forward. The other important documents which the trustees are responsible for is are your member benefit statements, your paid up certificate, transfer certificates, and investment statements if you actually issue, if your administrator issues that. This function is generally actually outsourced to the administrator, but I think that it would be prudent for the trustees to make sure that the administrators are updating all of these documents so that they clearly reflect what is your vested portion and what is your non-vested portion. And that is important for members because from a financial planning perspective, they would need to know exactly how to actually manage their affairs going forward. I mean, one of the requirements or one of the duties of the trustees in terms of Section 7 of the Pension Funds Act is to actually make sure your members are kept appropriately informed. And this is where the trustees would actually be responsible to make members fully aware of the implications when they leave the fund, how de minimis rules apply, which part of money will the de minimis rules apply to, and all of that needs to actually be included in some form of communication. Again, your paid up certificates and your transfer certificates also need to actually clearly indicate what your vested pot and your non-vested pot is. And we will, and you would need to consider that through your administrator. As I said, most of this is outsourced to the administrator, but I think it would be prudent that trustees make sure the administrator's done this. The other important thing for the trustees is to look at their rules. And this issue is quite important because if you look at the way in which the definition of pension, the definition of provident fund and pension fund in the income tax provides, it says that your rules must provide for the following. And one of the issues under that particular definition is how benefits are payable. So importantly, you need to actually make sure that your benefit payment rule on retirement has been amended to allow for so much of the amount that that can be commuted as a lump sum as prescribed by the Income Tax Act. If you don't have that, it is, if you basically don't clarify that, you will have a problem in terms of going forward. And payment of benefits, because you could be challenged from a member saying, why is there vested and non-vested benefit? Even though the law says that, you could be challenged, but your rules don't allow for it. And we all know that the legislation always supersedes the rules, but we often get determinations from the adjudicator saying, well, you didn't amend your rules to actually provide for it. This rule amendment issue could actually be an issue that comes up in an inspection with the FSCA when they're inspecting your fund. So it's important that you actually make sure that you've actually amended your rules accordingly. The transfer rules going forward from 1 March, the transfer between funds are, between all funds are tax-free. So particularly if you actually have a pension fund that has a rule that restricts the transfer to a provident fund, you would need to amend that. You would also need to amend your pension fund rules if you actually want to do transfers from a provident to a pension going forward because of consolidation. So importantly, this is something that you need to look at as trustees, or you'll get proper advice on it from your fund consultant or your fund advisor, and determine what the best way forward. We have, I've actually spoken to the FSCA on this issue. They are very comfortable that the rule amendments that you're submitting in line with the changes for 1 March, if it's submitted timeously, will be approved before by 1 March. So we don't foresee any problems of a backlog with the FSCA on the rules approval. In addition to that, retirement benefit counseling, as per the default regs, we were, funds were required to actually put in place either a retirement benefit counselor or retirement benefit counseling services. Some funds have chosen to have a counselor. Other funds have chosen to actually do retirement benefit counseling through communication. You need, and one of the requirements were that you need to actually provide communication or pre-retirement notification to members explaining what the options would be when they actually reach retirement date. So if you actually are providing counseling services as opposed to a counselor sitting behind a call and giving fund information, you would need to also look at that, your pre-retirement notification, so that the amendments are done to that kind of letter, and that your counselors are also trained adequately so that when the questions are actually asked to them, they are able to answer this. The other big issue for trustees is making sure your fund consultants or your fund advisors are fully au fait with this particular change in the legislation and understand fully what the impact would be when you consolidate, when you want to consolidate funds, when Section 14 transfers has to happen, so that you get the proper advice from your fund consultants and you manage that process in terms of the rules of the fund correctly. When can we move on? So the second part of this discussion is on what fund administrators need to do. And obviously this is slightly different in the sense that different administrators have taken different decisions regarding this. Some administrators have chosen to actually, there's a great need for systems development. And obviously with the uncertainties that we've had, most administrators tried to err on the side of caution and apply the law strictly and develop systems according to that. Others actually thought, well, we have to do what's best for members, so systems were developed in that particular way. And equally, some administrators actually decided to actually keep two separate records for your vested and your non-vested benefits, which then actually meant, and others actually said, well, we're not keeping two separate records, we're keeping one record, but we're separating it and we're having two pots of money. Whatever your administrators have decided to do, from a systems development perspective, trustees need to be satisfied that they've made provisions to actually make sure that whatever's accumulated before 1 March 2021 is treated as their vested pot, and the growth thereon is kept, doesn't need to be kept separately, but you can actually differentiate between what money is accumulated before and what money is accumulated after, and whatever growth there is on, because that's how you will determine whether or not what the vested and the non-vested pot of money is. For members over 55, some administrators on their systems development actually chose to not do anything for members over 55, because in that particular fund, for as long as they remained in that fund, they would have one record. The issue is that if they had decided to transfer to another fund as a result of change of employment, any contributions to that new fund would be a non-vested benefit. So a lot of administrators kind of made, just kept the same kind of record for over 55 members. And it's only when you actually move into another fund, that's when the new fund will keep the two separate records. So so that's how systems have been developed. Obviously, from an administrative perspective, we would need to, there's a lot of documents that we require when there's a Section 14 transfer, when there is your monthly employer schedules to categorize vested versus non-vested. So from an administrative perspective, if this is a development in terms of your systems, you need to actually make sure that you've actually covered for that. You've covered that as well. Tax directives and SARS requirements in terms of the business rule specification, or the BRS, like we all know it to be. There's been so much discussion around this with SARS. that we've asked for so much of clarity on so many issues. It seems to be coming along. And my understanding is from a note that SARS issued about 2 weeks back, is that the testing for annuitization, or the testing dealing with where there's post-annuitization, post-1 March benefits will kind of start around the 22nd of March. So any transfers or any tax applications done before then will not actually be affected by it. Equally, most administrators do not have direct interfacing with SARS. And if you don't, you have a third-party tax service provider. Those tax service providers you need to make sure as a fund and the administrator, so that the tax service providers like EB-Tax or iTax or whatever is fully conscious of the requirements that have been put in the BRS by SARS, and their systems have actually changed in the same way. The last thing from an administrator perspective is, which needs to actually be considered, is your procedures, your manuals and training that need to happen internally within the business. Importantly, training for your staff, training for administrators to know when and how vested and non-vested benefits are treated, to know when you're actually applying for a tax directive, how to complete the tax directive with the different pots of money that you have. So in that regard, we also need to administrators need to do a lot more work around making sure that the staff is properly equipped and understand this legislation, so that when they actually do these applications with SARS, or when they're actually telling members about what benefits they're entitled to as a lump sum and what benefits are subject to the annuitization principle, they are not actually misleading them or giving them incorrect information. Form changes, that is also a big issue for the administrators. I mean, and we all know that you on retirement now from a provident fund, you're going to have 2 pots of money. Your elections for that benefit has to be separated because one pot of money you probably only is available as a full lump sum, whilst the other may be subject to annuitization. So your retirement claim forms need to be changed. Like Hetty said earlier today, it depends on the fund, it depends on the administrator, how they decide to treat pre-retirement withdrawals from the fund, whether or not it's going to be reduced proportionately, or whether or not you're going to take everything from the vested pot, the non-vested pot, and you then have to look at your withdrawal notifications or your withdrawal claim forms. From a SARS perspective, through the industry, we've done quite a bit of changes. We've made quite a bit of changes to the recognition of transfer forms. We've submitted it to SARS, and we're waiting for confirmation from SARS that they will accept those changes, because it will be a standard document that would be used throughout all the industry, and all administrators would be using the same document. And that's also to cater for your vested versus your non-vested portions. At the same time, we haven't seen anything from the FSA with regards to changes on the Section 14 documents. And generally, when you actually have a Section 14 application, you have a asset value transfer, so you don't have a split transfer. But obviously, your transfer schedules is going to, from the administrator or from the transferor, the administrator of the transferor fund has to be quite specific in terms of what part of the benefit is a vested benefit and what part is non-vested, so that the new fund can record it in a proper manner. So my understanding is that the SARS and FSC are meeting today, and there is going to be some training being done on this new annuitization principles, and what's going to happen. And post that training, they will actually look at how the forms need to be changed. From an administrative perspective, the way in which we generally, and where there's an individual transfer, and this applies more to the retail side where there's an individual transfer, and you've got a form, the way in which you know how to allocate the money is through a Form J. So we trying through the IRF to kind of come up with changes to the Form J, so where we can actually see the vested versus non-vested. And once we finalize that in line with what the recommendations we made for the changes on the ROT, it would be made available and administrators would be able to use that going forward. Can we move on? So the last thing is what employers need to do. Obviously, this was actually done prior to us actually getting the notification from SARS yesterday on how contributions for February and how they should be dealt with in March. But what everybody or most funds and administrators have done is they've cautioned against the February contributions being paid in March because we weren't certain whether it would form part of the vested versus or the non-vested part. This change, I mean, following communication again from SARS yesterday, we now know that it actually is going to still form your February contributions as part of your vested benefit. So for those employers that we went out to and said, please pay your arrear contributions before March, please pay your Feb contributions before March to benefit members, we've got a little bit of reprieve from that. So for those people that represent employers in the audience, if your employers received this notification, it was based purely on what was actually in the legislation. It was not based on the fact that SARS was going to give us a different interpretation on this, which came out yesterday. Communication about this changes. So importantly, and why I keep stressing on the Section 14 issues is that when there's a transfer or when you trying to get an employer to move from one fund to the other, you've got to do member benefit presentations, or when the employer's made the decision to actually move from one fund to the other, you've got to do member benefit presentations. So to employers, to employees, or to give advice if you're a financial advisor of the employee when that employee is retiring. So these changes, the annuitization rules are very important in how they make these decisions. Members need to be fully aware of what they're going to get when they retire. What part of money actually is always going to be available as a vested benefit. What part of money that may be subject to annuitization if it is over the de minimis amount. If you withdraw from the fund, does annuitization affect you? So those kind of things advisors need to actually make employers aware of it. And when doing presentations or member benefit presentations for when there's transfers, to make sure those kind of things are included in the presentation so members are kept informed at all times. And that's all from me, Wayne.
Thank you, Nancy. It's very practical and useful. I think it provides some clarity. And I think the one issue that many people were concerned about are these forms, especially, not from a practical point of view, but just the Section 14 forms and those how to affect transfers, and then the clarity on the rule amendments and the ability, or the FSCA's ability to process them when they received. Just to touch on that one, the FSCA said that if you submit the rules timeously, they'll register them timeously, whatever that might mean.
Yeah.
Okay.
So if you remember when default regs came into play and then it was effective at 1 March 2019, everybody actually did all of the changes like right at the last minute. And then the FSC's website, submissions website crashed, and we couldn't actually get what we needed timelessly. So, but I mean, the FSCA has actually given us assurance that, you know, they fully equipped to deal with these rule amendments, because it's not major rule amendments, but it's rule amendments that's required in terms of the Income Tax Act. And equally, you know, from a member perspective, the rules are the governing document, and you need to make sure that it's quite clear in the rules how this is going to work. I can tell you that, having spoken to the FSCA and with them and SARS meeting today, we may see changes to the Section 14 documents in the conduct standard. So, or they might actually give you direction on, as an administrator of a fund, how your schedule should be looked at. But if you remember correctly, last year there was a circular issued on contributions and how you needed to actually split out contributions. It was still draft and we had to give comment on it. So I think that, I mean, if they're going to revisit that, then they would actually kind of make the contribution schedules on a monthly basis clear enough to cater for both vested and non-vested benefits. And then your transfer schedules will also cater for both vested and non-vested. Because if the transfer fund does not give this to the transferee fund, they're never going to know how to do it. And members may be prejudiced by the new fund placing it into the wrong pot of money.
Thank you, Nancy. And just that reminder that when making amendments that relate to legislation, try and keep it simple and just deal with what's required, rather than adding on anything else that you might have wanted to add on, you know, to rule amendments that you were busy doing.
Yeah, I think that the FSC has made that clear over the years that, you know, if you're doing a rule amendment and it relates to a legislative change, the rule amendment must only deal with the legislative change in order for it to get approved more speedily. But if you're actually going to put a whole lot of other rule amendment changes into the legislative update rule amendment, it could take longer for them to actually approve it.
Thank you, Nancy. I see Enos's hand is up. Enos, did you have anything you wanted to add?